New Jersey has one of the most tenant-protective breaking lease frameworks in the country, shaped by the state's powerful Anti-Eviction Act, comprehensive consumer protection laws, and a legal culture that aggressively protects tenant rights. The governing law includes the New Jersey Anti-Eviction Act, NJSA 2A 18-61.1, the Truth in Renting Act, and general contract principles. If you're a landlord or tenant in New Jersey, understanding the breaking lease framework is critical because the state's approach heavily favors tenants and the consequences of non-compliance are severe. Let's start with the landlord's duty to mitigate damages. New Jersey law clearly requires landlords to make reasonable efforts to re-rent a unit when a tenant breaks a lease and vacates. This duty is well established through case law, most notably the landmark New Jersey Supreme Court decision in Summer v. Credell, which is one of the most widely cited mitigation cases in American landlord-tenant law. Under Summer v. Credell, the landlord must treat the vacated unit the same as any other vacancy, advertising, showing, and accepting qualified applicants. The landlord cannot hold the departing tenant liable for the full remaining rent without making reasonable efforts. If the landlord fails to mitigate, the departing tenant's liability is reduced or eliminated. New Jersey courts take this duty very seriously. The Summer decision established New Jersey as one of the strongest mitigation duty states in the country. The departing tenant's liability is limited to rent during the vacancy period plus reasonable re-rental costs. Once a replacement tenant moves in, the departing tenant's obligation ends. If the landlord delays re-renting unreasonably, the departing tenant benefits from the landlord's failure. Early termination fees in New Jersey must be reasonable and consistent with the state's consumer protection framework. The Truth in Renting Act and the Consumer Fraud Act provide tools for challenging fees that are excessive or unconscionable. A fee of 1 to 2 months' rent is generally considered reasonable. Larger fees, particularly those that approach the full remaining lease amount, face serious challenges in New Jersey's tenant-protective legal environment. New Jersey's Anti-Eviction Act adds critical context. In most New Jersey residential tenancies, the landlord cannot terminate the tenancy without just cause. This means that once you accept a tenant, removing them is extremely difficult, making the breaking lease dynamic different from most states. When a tenant voluntarily breaks the lease and leaves, the landlord loses a tenant they can't easily replace through the eviction process. This dynamic makes prompt mitigation even more important. Military members have the right to break a lease under the SCRA. Joint Base, McGuire-Dix Lakehurst, encompassing Air Force, Army, and Navy operations, generates significant military rental demand in Burlington and Ocean counties. SCRA terminations are regular occurrences. New Jersey has enacted protections for victims of domestic violence that allow early lease termination. Under NJSA 46-8-912, a tenant who is a victim of domestic violence or sexual assault can terminate by providing written notice and a copy of a temporary or final restraining order or a police report. The tenant must provide at least 30 days' notice. The tenant is responsible for rent through the termination date, but not the remaining term. The landlord cannot charge an early termination fee. Tenants may break a lease if the landlord fails to maintain habitable conditions. New Jersey recognizes a strong implied warranty of habitability, and the landlord has extensive obligations to maintain the premises. If the landlord fails to address serious habitability issues after proper notice, the tenant may terminate. From a practical standpoint, New Jersey has a large and diverse rental market. Northern New Jersey, particularly Jersey City, Hoboken, and Newark, functions as an extension of the New York City market with strong demand and quick re-rental. Central New Jersey, the Route 1 corridor, New Brunswick, Princeton, has strong demand driven by pharmaceuticals and technology. Southern New Jersey, Camden, Cherry Hill, is influenced by the Philadelphia economy. The Jersey Shore has seasonal dynamics. One critical best practice for New Jersey landlords: treat screening as your most important business process. New Jersey's Anti-Eviction Act means you cannot easily remove a problem tenant once accepted, And when a good tenant breaks a lease, New Jersey's Summer vs. Credell mitigation standard means you must re-rent promptly. Document every mitigation step meticulously. New Jersey courts scrutinize landlord behavior closely. Another best practice: never include lease provisions that attempt to waive the mitigation duty or that impose the full remaining rent as liquidated damages without mitigation. These provisions are unlikely to survive challenge in New Jersey's tenant protective courts. New Jersey limits the security deposit to 1.5 months' rent. The deposit must be held in an interest-bearing account. The deposit must be returned within 30 days. These rules apply whether the departure is a normal move-out or a broken lease. For the complete guide to New Jersey breaking lease laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our Breaking Lease Law series.